Looks like everyone is ready. Ms. Stewart, you may begin.
Under Iowa Code, a guardian ad litem for a child prosecuting witness is limited to assisting a child witness while the witness is actively participating as a witness during the trial. For example, if there's assistance needed to determine if a child should testify via closed circuit or in person, if the child needs a break during their testimony, things of that nature. However, Iowa Code does not allow a guardian ad litem to become a de facto prosecutor and argue the legal merits or legal issues of a criminal proceeding, which is what in fact happened in this case. In a criminal case, the interests of the state and the defendant aren't directly aligned, but the interest of the child testifying witness is not a factor in the criminal proceeding, which means that the witness is not a party to the case. And therefore, any input that the guardian ad litem has to legal merits should not be considered.
You know, I will just say, me personally, I have some concerns about what you're talking about, that the guardian ad litem at times seem to be sort of a second prosecutor. But there was no objection to any of this below. So, and it seems to me to be very difficult to establish that there would have been a different result, or there probably would have been a different result, or whatever the Strickland standard is, if the guardian ad litem had not done those things. So don't we have to find a structural error in order to do anything about this issue?
Yeah, I do. I don't think so. Well, although I do argue that in my brief, and of course you're welcome to find structural error, but as far as the ineffective assistance, here the first layer is obviously that counsel had a duty to object to these issues. And I think in this case, because there are several instances, I think I cited 8 instances where the guardian ad litem, in our argument and estimation, overstepped what the code directed her to do, that should have been a red flag to the attorney for the defendant. And we know that an attorney has a duty if there's case law or statute, or if there's case law from other states and jurisdictions, and all of that happened here. So I think we'll be able to establish that there was an essential duty here. And I think you're referencing the prejudice as far as the attorney, the guardian ad litem, acting as a prosecutor. In our estimation, in our argument, the prejudice is clear here. When Mr. Skahill went into his trial, the expectation was that he was going to have one prosecutor arguing against his case. In this case, he theoretically had 2. Oftentimes, the district court would ask for the guardian ad litem's opinion, wouldn't render decisions until after the guardian ad litem provided her opinion. And so we can assume that the guardian ad litem's opinions, which were often, well, not often, every single time aligned with the prosecutor, had an effect on some of the outcomes that the judge made. And some of those outcomes could have directly impacted the guilt or not guilt assessment by the jury. And so with that argument, then the prejudice is in fact established.
Ms. Stewart,
Yes.
can I turn your attention to the CPC, the interviews that were done? I agree that there's some concern about the GAL issues, but those are preserved for now at least. I think it's fair to say that the admissibility of CPC or forensic interviews has been an ongoing and relitigated issue. I'm not sure that there's been a good resolution of it necessarily. So in your view, other than saying they should never be allowed, which I assume would at least be your first take at it, what would be a workable rule that makes sense given the rules of evidence and kind of the purposes for which we would want to have these in some cases and maybe not in other cases?
So first, let me state for the record that you are in fact correct. My first argument would be that they never get allowed in. But the residual hearsay exception, which is often how they are allowed into evidence, is really meant to be an exception that is rarely used. Instead, we find ourselves using it repeatedly for the CPC videos. In my case, in this case particularly, and some of the other cases that have come before with the litigation, it's always been a question about whether these CPC videos are necessary. In our estimation, the line is if the child witness is there testifying to what is in fact in the CPC video, then there is no need for the CPC video. Really the CPC video is needed if the child is struggling to testify, all of those things. And in this case, particularly, the child never struggled to testify.
So how do we, or how does a district court judge draw that line in the heat of the moment if the standard is going to be the sufficiency of detail of the witness's testimony, and maybe that's even a relative comparison, it's something more like the sufficiency of detail as it relates to the CPC interview? I mean, it seems very hard to manage. How would you address that?
I can concede that it would be hard to manage, but I definitely think part of the CPC video coming in also, you have to evaluate the credibility of the witness. That's another thing, because the CPC video, we're arguing that the CPC video, when it came in, just bolstered whatever was already happening, but the jury here was already able to assess her credibility when she took the stand. I think, back to a previous case, I argued Fontenot, where we talked about when CPC videos can come in, and I think one of the standards would also be, I think, prior consistent, inconsistent statements. All of that lends itself to what the witness is testifying to versus what's on the CPC video.
Counsel.
Records exception that's been argued at least on appeal. Not presented below, at least I don't think it was presented below. We have a DeVos case that might suggest that certain evidentiary errors don't have to be preserved, but for the prosecution at least. But the bottom line, the question I want to ask you is, why wouldn't the medical records exception related to diagnosis and treatment, why wouldn't that exception apply here?
The CPC video in this case wasn't used for medical diagnosis. The testifying witness in this case, she had gone to an ER prior to the CPC video. So when she got to the CPC center where they took the video, they were no longer using it to try and diagnose what was happening. They knew who the alleged assailant was, and this particular instance, they were really just gathering evidence. There was a two-way mirror. There was a police officer behind the mirror taking notes. The police officer was able to, I believe, call in if there was anything to the interviewee, if there was anything he wanted asked. I don't think he did that in this case, but it's very clear from our point of view that it wasn't being used for medical diagnosis.
Counsel, 5.807 is a fairly high bar. What are we to make of section 915.38 sub 3? What work, if anything, does that statute do?
To be honest with you, give me a little more background on the statute there, if you don't mind.
This is a statute that basically says that if the video substantially complies with 5.807, then perhaps it comes in. And it's not something that we've dealt with very much, but the statute is there. It's referenced, I think, in the state's brief at a couple of points. What do you say we need to do with that, if anything?
I think we should treat it just like we treat the residual hearsay rule as a whole, that it's not meant to be a catch-all for anything that the prosecution wants to put into evidence. I think the residual hearsay standard is there for a reason. You look at that first, and in this case, again, there was no necessity for it to come in. There was no reason for it to come in, and that should be the overall standard.
But hasn't the legislature said it shouldn't be treated the same, because 915.38 refers to that the statements of a child, the recorded statements of a child, if they substantially comport. Doesn't that make it different than other statements of a defendant or witness, for example?
Our argument would be, no, it should be held to the same standard. I think that it doesn't mean that it automatically should come into evidence.
No, I didn't say automatically, but
Yes, ma'am.
substantially comports. Doesn't that make it a different standard?
I would disagree with that. I would say, again, that if there's no reason for it to come in, even if it substantially comports, if there's no reason, if there's no evidentiary value to it coming in, then it shouldn't just be able to be entered into evidence.
I'd like you to address the harmless error issue between CPC Video 1 and CPC Video 2. The Court of Appeals ruled that Video 1, it was satisfied that should have come in, but Video 2 should not have, but they found it to be harmless error. Could
Yeah,
you
I
address that?
I'm sorry. Okay. Yes, I think it goes back to the statement I made earlier about bolstering her credibility and using that CPC video to underline and bolster or up, the testimony that she had already given. And so I don't think that it added any value. And so the harmless error here is that now the jury got to hear the same thing twice and got to evaluate her credibility both times. And maybe that secondary video credibility added more to what she had already, testified to in person.
But actually, they got to hear it more than twice, isn't it? Because the jury had a question and said, can we get a transcript? And the court said, no, you can't get a transcript, but here's the DVD of the first CPC interview. You can listen to it again.
No, I think that's absolutely right. And I think if you think about that question and then being able to review it again, that means they were giving credence to what was, a heavy credence to what was on the video versus what she testified to. And of course, that creates the error, and it's not harmless.
Counsel, was there overwhelming evidence of guilt without the video?
My argument would be that there wasn't overwhelming evidence of guilt. Without the video, the jury might have just considered and said whatever she was testifying to in person was not, valid or acceptable. But that second, the viewing of the video might have bolstered or added to. And so, again, not harmless, excuse me.
It's sort of a fine line because on the one hand, you're saying that the video wasn't necessary. On the other hand, to the prosecution's case. On the other hand, you're saying it's harmful to the defense case, right?
Yes.
I guess you can divide it because the residual rule has a sort of a necessity is a term of art. It requires a showing that the evidence be more probative than other evidence that would be available on the point. And I guess that's the issue I'm going to explore with
Yeah,
Mr. Miller.
that's exactly the argument we're making, that there was this didn't need to come in because there was other evidence at hand that they could have used to get the same information, in which they did use. So if there are no further questions.
I want to back up a moment. You just said that there was no other evidence or that there was other evidence and they didn't need it. Was this more than just a he said, she said? What is that other evidence you're talking about that the state could have used?
Oh, I'm sorry. I'm talking about the testimony that she gave in person live. And it was a he said, she said, which is oftentimes what it is in these cases. But I was just referring to her live testimony versus the video CPC
Thank you.
testimony. Okay. If there are no other questions, I'll concede the rest of my time here. And I'll see you back on rebuttal.
Mr. Miller.
Counsel, this court should affirm the defendant's convictions because the defendant has not shown he received ineffective assistance of counsel from the guardian ad litem's participation in the case, and because the CPC interviews were properly admitted, and because there was harmless error, if there was any error at all. I'll just briefly touch on the GAL issue, which is that the defendant here, his argument bears no relationship to the text of the statute. The statute is very broad. It says that a guardian ad litem shall support and advocate for the protection of the child, but not be allowed to introduce evidence or cross-examination. Advocate to protect is a very broad term. It would include physical protection from an abuser. And so making an argument to support and protect a child is a broad standard. It's not just There's no language that just limits it to providing emotional comfort during testimony. That's why they're allowed to attend even the trial.
I mean, you do say this in your brief, and you're repeating this now. Basically, your position is the GAL can do whatever is in their power, other than the two specific things they can't do that are
That's
listed in the
correct.
statute to get the defendant convicted, right?
Yes, I think that's true, unless there's a separate constitutional backstop that would prevent it. None has been suggested here. Moreover, the GAL could also conclude that the allegations aren't in the interest of the child's best interest to pursue and could take positions contrary to the state. It's not necessarily the case that they're going to be in lockstep with the state. So,
Boy, I don't know. The legislative history is that the statute first appeared in about 1985. And that was during the time frame we had Coy versus Iowa and Maryland versus Craig. Those are the cases that dealt with, kind of protection of child witnesses and so forth. And so the context of the statute is, at least the immediate stimulation seems to be the need to protect child witnesses in the criminal justice process. And clearly under the statute, you can protect the witness from aggressive cross-examination, barriers maybe, et cetera. But to say that allows the guardian ad litem to be about a second prosecutor is, to my thinking, quite a leap. It seems to me the historical context cuts against some kind of broad reading of your statute. Push against it.
I think that if we look at the words used in the statute, there's no limit that suggests that. They say advocate to protect, including being at trial to do so. Now, of course, even if you're advocating to protect, the limits that are in the statute, excuse me?
I guess the statute arguably talks about protecting the witness. Now, the question is, what does that mean, I guess? Protect the witness as witness?
It says protect the child. It certainly talks about witnesses earlier in the statute, the child witness. That's true. That's how you'd be eligible. But it talks about protecting the child. And the statute puts limits to prevent a second prosecutor in the sense of the GAL can't file charges and the GAL cannot introduce evidence, or at least separately introduce evidence at trial or cross-examine witnesses. And so in that sense, the state is solely responsible for meeting the burden of proving the defendant guilty beyond a reasonable doubt. Now, of course, here you could preserve it. I think that the statute is sufficiently clear, especially with the argument that the defendants made that counsel wasn't ineffective for not making this argument. You can reject it, but you could certainly preserve it as the Court of Appeals did. Similarly, you could reject the argument right now on prejudice grounds because the state offered a strong case of guilt here. We had the child's testimony that he touched her genitals. She demonstrated, of course, from the record, it just says indicate, but in the CPC video, she makes this motion of what he asked her to do when he exposed his penis that was sticking up. The mother testified that the child told her about the abuse.
Can I follow up on your comment regarding the CPC interview? Let's assume a jurisdiction set up a victim protection center, and every person crime, the alleged victim would go in and do essentially a forensic interview akin to what we do with child protection. Is it the state's position that as a kind of a matter of course then it would be permissible to allow these victim protection center interviews into evidence because the victim gives more detailed accounts of the crime in the one-on-one setting and they're longer? Or is there something unique about child cases that we need to be considering?
I think that we would say that we should analyze those cases like we have done in Vervenka and the cases that preceded it, which we look at a panoply of factors, including the detail of the testimony, how natural it is, how able the jury is to compare the witnesses, assess their credibility at trial versus in the video. Here we had closed circuit television with...
I guess I'm struggling with that issue, and you can persuade me. I think this is a tough issue. I really do. But, I mean, the purpose of the trial is to have the state marshal its resources and its evidence and present a case to the jury, generally with live witnesses. And I think in all circumstances, we would agree that people sitting in a room with a trained interviewer who can have conversations for hours at a time will give much more detailed testimony than someone on the stand. And that just seems to be not the way we want to try cases, which is, in a clinician's office and then just present the DVD to the jury. The flip side, I understand that there's a need for it, and certainly there's a trend in the case law that allows it. So that's really my way of telling you, persuade me one way or the other, because I think it is a tough issue.
So in terms of the broader all-witness type of situation, as Justice McDermott and Chief Justice Christensen pointed out, we do have 915.38 that says that if a child CPC video substantially complies with the residual hearsay exception, it is admissible under that exception.
Yeah, but there was no finding of necessity of the district court at all, I don't think.
Before trial, there was a finding of necessity. The objection to the motion, to the video, was renewed at trial, and the district court continued to stand by its ruling. Presumably, it continued to believe the video was necessary after the victim had testified, and so there was a necessity finding, Your Honor.
Oh, well, thank you. And what was the necessity exactly?
The necessity finding was that because this was a situation where there was abuse in a room with just the child and the parent, that it was necessary to admit the video.
It always comes in those kind of situations. It's a categorical admission.
Well, I think that because that was the finding that was here, we can still look at the entire record to see if that finding was correct. And here we have a 7-year-old child who was 8 at the time of trial. She had to testify by closed circuit television with the attorneys in the courtroom. She's in the law library. She gave less detailed testimony at trial, although she was able to certainly say what happened to her.
But that's because that's what the prosecutor chose to ask her. I mean, the prosecutor asked 10 pages worth of questions, maybe at most. I mean, as Justice McDonald said, really comparing the first DVD to the trial testimony, they line up pretty well, and it does come across as kind of bolstering, particularly when the prosecutor in closing argument is arguing the DVD and just playing it, arguing it, playing it, arguing it, playing it, arguing it. That seems to me maybe not our Anglo-American conception of how trials are supposed to work. I don't know. Help me out.
If you look at the text of the rule, it says, is the most probative on the point. In a detailed, relaxed conversation where there's a back and forth between the interviewer asking open-ended questions, where you have a 7-year-old child who's directed that they need to tell the truth and confirms that they understand that, that's the rule of the room, and you have those guarantees of trustworthiness.
Except my understanding, and part of the problem with this is that my understanding is that the interviewer is not trained to push back and try to undermine the child's story during the forensic interview. So you have a statement that maybe the interviewer doesn't accept at face value, but the interviewer is trying to facilitate conversation, draw out information, but not testing it and probing it to see whether it makes sense, whether it's internally consistent. That seems to be very problematic, and I guess I don't know why we would want a rule that would alleviate from the prosecutor the responsibility of asking better questions, right? You can ask the witness, could you provide the jury with more detail? I know this is uncomfortable for you. Or follow the CPC interview and just kind of ask the same question. Why do we want to have a rule that allows the prosecutor duties to be transferred to a forensic interview done at a prior date?
Well, I think that the rule doesn't just apply to prosecution, of course. It's the residual hearsay rule that applies to all cases. The legislature has decided that the CPC interviews in particular could be amendable to this rule as a matter of policy.
Let me ask a question. I think there are many instances when that first video from however long ago it was, and in many cases, it's impossible to go back, even if you'd ask the same questions. I understand there are many situations where it's impossible to go back and elicit the same response unless you have the child watch the video again, which many prosecutors intentionally say, we don't want to have the kids see the video beforehand. So let me just give it to you. Let's just assume for argument's sake that the first video got in and that would be affirmed. I want you to talk about that second video and whether or not it was harmless error. I need to have you first answer, would you agree with me, the question I asked Ms. Stewart? It's a he said, she said, because even if you have mom testify, she's testifying about what the kid said. Nurse is testifying about what the kid said. So it's pretty much the kid's word versus the guy's word. Is that correct?
Not quite, Your Honor. There's a medical record from the emergency room that notes a scratch on the genitals of the child that was from the day of the disclosure, I believe, which was the timeline on the disclosure is unclear. It was the abuse most likely happened Thursday or Friday. The disclosure was Saturday as soon as she returned home. And the emergency room examination showed a scratch on her genitals near the urethra, which is physical evidence and makes this case fairly different than a lot of these types of
Many
child
times that's
abuse
not
victims.
evident. But in addition to that, is it he said, she said?
I think that the consistent telling multiple people over and over consistently what happened, it is a he said, she said, but there's in many indications that it's a truthful report beyond just a single statement that was never tested and not reiterated.
When credibility is central to a case like it would be in this case, doesn't that make it a little bit different as to whether or not it was harmless?
It certainly could. I think in most cases where you have a victim, the testimony of a victim is going to be quite important. That doesn't mean that you can't have a harmless error type case. And I think it's also worth pointing out here that the defendant testified, said he didn't do it, and the jury didn't believe him. The jury got to assess the defendant's credibility and rejected it and essentially found that he wasn't telling the truth.
Counsel, how do we apply as a court 915.38 sub 3? What does that mean exactly? I mean, what does that have us do?
I think that at the very least, it's an indication that CPC videos should be strongly considered to be admitted under the residual hearsay rule. I think substantially comports with, I think means that it needs to essentially comply with the dictates of the rule, although perhaps with a little bit more leniency than you might otherwise apply.
But we said 27 years ago in Rojas, we talked about the statute, and we said the statute doesn't change the analysis under the residual exception rule.
Right.
Doesn't change the analysis. In other words, it doesn't do any work. And we've never really relied on it since then as meaning anything other than the rule itself, right?
I mean, in terms of, to the extent the court's asking about the policy behind these videos and why they're important, the legislature has made a determination that having these videos as an avenue to be admissible under residual
Well,
hearsay
Counsel, if they were going to make that, why even say it needs to substantially comply? Why don't we let the legislature say CPC videos come in?
they certainly could have done that, and they made
Right,
clear-
but they didn't. They said it has
Right.
to substantially comply with
Correct.
Residual hearsay. So that means we really need to look at residual hearsay.
Right,
yes?
and in here, this video complies, at least the first one, complies with the residual hearsay exception because it is the most substantial evidence on the point for which it was offered. It's a contemporaneous, roughly contemporaneous statement by a 7-year-old
But it
child.
wasn't really different than her own testimony, so it can't be better than her own testimony.
I think that it was more detailed. It's a more natural conversation and allowed the jury a chance to assess her credibility, especially.
Which
but
essentially would allow any CPC video.
I don't think so, Your Honor. I think the age of the victim would be an important factor. I think the development of their testimony, I think whether they're able to testify live in court. Here, the court made a finding that they could testify by closed-circuit television because of the emotional difficulty for the child.
You made a comment that the residual hearsay test had been satisfied. There wasn't any finding, and you can correct me if I'm wrong, maybe the defendant conceded, but there wasn't any finding by the district court on materiality or necessity, or I thought interest of justice was what the court focused on.
The district court made a necessity finding. It made, I think, interest of justice. It was 3 of the prongs that it addressed. Definitely addressed necessity, I believe, interest of justice and trustworthiness. But the defendant only challenges the necessity and the interests of justice here. And also, Your Honor, because this is review on of a conviction, I think that if the record reflects that it was admissible, you can hold the errors harmless.
Can I ask a follow-up, Chief? So how do we measure what's most probative? From whose point of view? I mean, I feel like you're using the term most probative evidence, meaning the evidence that's most strongly in favor of the state's case, which may or may not correspond to kind of its actual truth. So how do we assess that in, for example, a case where you have a recanting witness and the state's position is, well, it's the most probative evidence, even though maybe you get a witness on the stand that says, no, that's not true. So how do we evaluate what's most probative?
Right, I think that the contemporaneousness of these statements, as well as the age of the person making them, is what makes these CPC videos particularly probative at the time. That's why we admit them when someone recants, is because it's probative evidence, the most probative evidence available on the point. And I think that that is the reason that's the analysis in these cases.
No, I think you're going to get 2 follow-ups here. Go ahead, Waterman.
What's your best argument on harmless error if the second video shouldn't have come in?
The second video, so it was largely the same as the first video. The only additional evidence or statements was that the defendant touched the victim on the couch. Other times there was an instruction that those could only be used to evaluate the attraction of the defendant to the child, not actually for guilt. There's also Exhibit 6, where the doctor from the Child Protection Center notes that that sometimes when the defendant touches the child's genitals, it hurts, suggesting that there are multiple times that she reported multiple times the defendant touched her. So you have duplicative evidence. You also have the overwhelming evidence that we've talked about of the multiple people confirming the report of the child, as well as the child's testimony and the physical evidence as reflected in the exhibit of the scratch.
Justice Mansfield?
Thank you. That word probative, in reading both our case law on that and other federal case law, it seems that probative doesn't necessarily mean what you're taking it to mean, which is persuasive. Not necessarily it's the most persuasive, but probative is in the sense that it is truly the only evidence on something, not that it might be more convincing than other evidence that is available. So in this situation where the child witness can testify to the specific acts of abuse that are charged that Mr. Skahill was convicted of, it seems that maybe the video is more convincing. The prosecutor thought that, played it at closing argument, but is it more probative because the child testified to the very same things on the stand, right?
I think that it is the most probative because of the contemporaneous nature, the nature of the testimony with the closed circuit television, the development of the testimony. And I think that would be true even if at the first CPC interview she said no abuse happened and the defendant was the one standing here asking to admit the video. The rules would apply equally in both situations. I think that it does mean the most probative in the sense of best allows the jury to evaluate credibility and seek the truth. And I think in this situation, that is this video for the reasons that I've articulated, Your Honor. And so for those reasons, the state would ask that this court affirm the defendant's convictions. Thank you.
Thank you. Ms. Stewart?
2 points here. The first is that this case was a he said, she said, and so it really comes down to credibility.
Well, I don't know about that. I read Mr. Skahill's performance on the stand, and I think he hurt himself somewhat. I mean, it's hard to tell you when you're not there, but he told, as I recall, I mean, you've read it too, he told the jury that she had never seen his penis, and then he had to admit on cross-examination that he had told the police at the time that she had seen him shower before and may have even walked in when he was having sex with his wife. So that seems to me damaging. And then he was asked to explain the discrepancy and was asked, do you remember things better now or did you remember them better at the time? And he said, well, I actually think I remember them better now on further reflection. And I don't know, that didn't sound super persuasive to me, so maybe admission of both videos was harmless error. Is that a possibility?
No, I would disagree with that. I don't think it was harmless. And I think what I was getting to was it goes back to, since it's credibility, it goes back to what we were discussing about the probative nature. The witness is the best her in-person testimony is the best evidence of what's happening. And it goes to Justice McDonald's point. During trial, there's Q&A, right? There's the prosecutor asking the witness questions, and then there is the cross-examination. And that mechanism is really well put to use for the jury to assess credibility. They didn't then need the video to underline the assessment that they were already making in person. And that's what makes it harmful. And I think here, as in your previous cases before, I think Rojas was mentioned, if a child can clearly testify, and here she could clearly testify, she was 8 years old, she didn't forget or need assistance remembering, there wasn't a lot of refreshing of recollection or even impeachment, which means she clearly was able to testify to what happened. So that, again, the video wasn't necessary. And I think in talking about the defendant's credibility, if you compare it, the only thing the jury had to evaluate the defendant's credibility was his testimony. He didn't get videos or extra things of that nature, which could have bolstered his testimony. And so I think if you look at it like that, again, the video just added a harmful layer. And I think the video has to comply with the residual hearsay rules set out, and it didn't in this case because it wasn't necessary. And that in of itself is where the harm, again, comes in. And then just briefly over to the guardian ad litem portion. I think it's very clear in our statute what the guardian ad litem can and can't do. I think the very end of the statute says the guardian ad litem can't separately introduce evidence, you can't cross-examine witnesses. The flip side of that would be if you can't separately introduce evidence, you surely can't argue against evidence that's being introduced by the defense. And we know that evidence being introduced, cross-examination, that's the meat and potatoes of a criminal trial. And if the statute says that the gal can't do that, guardian ad litem can't do those things, then clearly it should be interpreted that she couldn't do the 8 separate instances that she did in this case. And there's prejudice there because all of the things she was arguing against were evidence that the defense wanted to put in to help establish the not guilty portion or not guilty evidence for the defendant. And so keeping all of those things out and her aligning with the prosecutor's argument clearly establishes prejudice. And the attorney should have objected to all of those things. And so it was ineffective.
How can we find that it would have changed the outcome of the trial, or would have been reasonably likely to change the outcome under Strickland prejudice?
Yeah, I think because it calls into question the veracity of the outcome. And if you can look at it and say possibly that outcome could have changed with any of those things, then that makes it prejudicial. I don't hear any other questions, so I'll wrap it up with that. Thank you. And we ask that you remand the case back for a new trial.
Thank you. The case of State versus Skahill is hereby submitted, and court is adjourned for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.